cool.
Here we go.
Audacity. Kirk is not an attorney. This is not legal advice. This is to be considered for educational purposes only.
Welcome to Kirk's Law Corner Live with your host, Kirk Pendergrass and Chris Hallett. Correct?
That's right.
Welcome, Kirk. Welcome, Chris.
Thank you, Ted.
Thanks, Ted.
Good evening, folks. Thanks for joining us tonight. Thank you, Chris Hallett, for coming on. Ted, thanks for everything that you do for us, promoting all this stuff here and being the techie guy over there, putting all this stuff together. It's a lot of work for you. We greatly appreciate what you do for us, make all this
Absolutely.
happen. Without you, this wouldn't be doing what it's doing right now, which is going live in many different places. Facebook, obviously, YouTube, Twitter, and wherever else it gets put out there in your other side program there. So it goes out quite a few different places. So want to thank our sponsors on Blog Talk Radio, Future of Our Children, Brian Kincher, Newell Shelton, Randy Davis, and Cheyenne Davis. If you ever want to listen in on Blog Talk Radio, go to Future of Our Children Network. There's several different shows that are on there. They're all archived. Brian Kincher does JAM, Judicial Accountability Movement. There's God and Country with Tony Pellegrino and Randall Stone on Saturdays. The Far From Normal show is on there as well on Tuesday nights on Blog Talk Radio, Future of Our Children. So there's lots of things that you can listen to on there. I haven't been able to upload all of our audios yet, so one day I'll get caught up on that stuff and get those up there. But they are obviously archived on Kirk's Law Corner and the Marchess YouTube, Facebook page, and Twitter. So it can be rewatched at any time, anywhere, really. So, but we do want to thank all of those that do tune in and participate, ask questions, willingness to educate and be educated. Because again, I don't know everything there is to know out there. So, if I say something that's you don't think is correct, feel free to message me on the side and say, hey, that's not right, and here's the evidence to support your claim that it's not right. Don't just blurt out that, oh, well, that's not right, because I'm pretty frugal with my research and what I know and what I've read. And, it's just law. Everything that I've read, most all of it's law. So it's kind of hard for me to actually be wrong when I'm reading what it says. So it's not my opinion that you're arguing with. You're trying to argue with the written language. So I mean, it is what it is. So Brenda says not good sound. Everybody hearing us out there all right?
Yeah, the levels are all fine on my end.
Okay.
Must be Brenda's end.
Asking the people out there if they're hearing us all right. If they're not hearing us, we need to make some adjustments here. And I don't know if it's just me talking quieter or sound difference. So anyway, so tonight got a couple different things I'd like to talk to you folks about, and one is the executive order. I just posted that here recently on Kirk's Law Corner and just blasted it all over the place, because what is coming? This is the thing that we need to understand about how our government actually works, as the internal working is like a corporation. Every year, they go to session, and that's from January through March. And what that actually really entails is, okay, every single agency gets funded, the budget for the year. And so every year they have to figure out the budget for each one of those agencies. Now, with what Trump has put out in his executive orders, and it was multiple orders, but this particular one is specific to the executive branch as a whole. Like the whole entire executive branch basically underwent audit, okay, to see if any agencies need to be abolished, if any of parts of the agencies, sub-agencies need to be abolished or reformed. That's kind of really all falls under that political power inherent to the people. Trump's just picked up that torch. And, you know, even in this executive order, he even asked for the people's help to help put it out. I really wish I would have found this sooner, but this all stems from what Chris Hallett was talking about. And, you know, for a while there, I was actually keeping up with the executive orders, and it just got too freaking crazy trying to keep up with everything all at once. But there's stuff that's going to be happening come this new legislative session. Some agencies may be defunded and completely abolished. Okay, and we're talking about the federal realm of things right here. So there may be some federal funding that, well, just no longer gets to state agencies. Some of those agencies like Bureau of Land Management, BLM, not Black Lives Matter, but Bureau of Land Management. I'm curious to see what kind of budget cuts happen there. And if there's any departments or agencies within the department of BLM that get abolished, defunded, because when that agency gets defunded, it's not in the budget, which means it no longer exists as functioning part of the government. It's no longer an agency that has, it just doesn't exist. It's like it's not there no more. You know, it's kind of like canceling your cable bill and you're going to DSL, CenturyLink, whatever it is in your area. You know, you cancel that bill, you defund that service. That service no longer exists. So that's on the real. That's how it works in our government. When it gets defunded, gone, bye. So that's some of the things they're coming out. That'll be coming out this January. Is, you know, basically at the end of March. You know, that's when the budget gets signed. So what doesn't make the cut or what does get cut, that's it. It's gone. So there's going to be some consolidations. You know, there's definitely where we have agencies that have little agency departments underneath the one agency, the department itself. That there's other from the EO, it specifically says that there's other parts that may be overlapping. And so you may have one department that has an agency that's going to be defunded and removed because it's going to be moved in with it under the appropriate area. So it's going to be consolidated. What this actually means is saving of money, tax dollars. It's going to lower our taxes because we're no longer funding these agencies. So, I mean, it's going to be a serious shakeup in our country. And, you know, if Trump keeps going the way he's going and, you know, doesn't get impeached because people are getting pissed that this is what's happening. This is the reason why he's being attacked. Because this is all about making America great again and putting the power back in the people's hands. Now, we'll just have to wait and see what actually happens. But according to his EO and his own words and what he's got going in the background, you know, things are going to change. There's no ifs, ands, or buts about it. We're going to have a change. And I'm hoping that it's for the better. I don't know if we can really get much worse, but yeah, it can. It can get much worse. But do we really want to go that way? No, let's actually try and make things better. So that's part of what I'm doing. I'm starting to work with some of my representatives. I'm talking with them. I'm getting with them, and I'm saying, hey, this is wrong. This is wrong. And a couple of candidate-elects, you know, hopefully we can get them in office. We need more liberty-minded people who aren't going to be bought off, who are not members of the bar, who are not going to be coerced.
Hey, now I resemble that remark. Sorry,
You're not a member
throw that
of
out
the British Accreditation Registry, Chris. In fact, you're the man who's trying to disseminate that whole frickin' mess.
Well,
God, I love you.
that's what I get for asking the question.
Well, all you did was follow orders.
Hey, that's what the president said. Help me out here, brother. I said, not a problem. I can do that.
Right? So that's the gist of that executive order, is it is under audit. And it was only supposed to go for 180 days. And then 180 days from there, they're supposed to implement the plan, which puts it right back to March 23rd. Okay, because 180 days is 6 months. So the first 6 months is supposed to be the people informing them of what's going on. Then, after all of the investigations and all that stuff, then there's another 180 days that they actually do the planning. And that puts it at March 23rd of January of 2018, which is the legislative session. So that at the end of March, when all the budget gets signed, that's when the change is going to happen, because there will be, and what that's actually called is the fiscal year, which is corporate talk for this year actually starts here, not January through December. That's our normal, calendar year. Fiscal year is the order of operation of the corporation in our corporation of government. Most of the time it's January 1st, or is it June 1st? June 1st. So all new bills, legislation, all that stuff usually come active unless it's directly stated, okay, this bill is active now. So at any time during the year, a bill could be passed. But most of the time, everything that's done between January through March all gets signed and all that stuff, and it becomes effective June 1st. So this next year is going to be an exciting year, at least in my mind, to see certain agencies get defunded or get reformed and abolished, and things are going to change. There's no ifs, ands, or buts. It's going to happen. It is happening. So hang in there. And then we need to do what we can do as the people and start informing our representatives, that First Amendment right, addressing government of our grievances. Write our letters, get a hold of them, talk to them. If you're knowledgeable on one little topic, perfect. Get in there and talk to them. Start exposing the truth. Hey, this is what the statute says. This is the legislative intent. But this is actually what's going on, because these people don't know what's going on unless we tell them. They live a totally different life, and their life is so consumed with, dealing with the legislative acts and the current hearings and all that kind of stuff. Their bill that they're trying to push through. They don't have time
to that point, Kirk, if I can interject something real quick here. It was an unexpected turn of events this year. When I wrote my first challenging the practice as a monopoly and citing that it, was become hostile. Anybody who's read the report knows what it says. But because I asked the question, that was, not only did it wake them up as far as the judicial branch was concerned, it also woke up Congress, which was an unexpected side effect. Because my question was to the judges, not to Congress. That came later. And, they said, okay, well, we've been doing it this way for so long. What are you talking about? Show us something.
Right.
So I said, okay, well, I'm going to show you something. And it's stuck. So it's not that they, to Kirk's point, they will listen. When you talk to them, they will listen, but it's how you address them. And that's the key issue. So when it comes to addressing your representatives, senators, congressmen, whoever, do what you know, do what you're good at. If you're good at writing, write. If you're good at speaking, speak. But at least do something. because not doing anything and then bitching about how wrong everything is not helping. So anyway, I didn't mean to interrupt there, Kirk. I just wanted to throw that out there.
The key point here is start complaining to the right people. You know, out here in Facebook land, you know, if you're in a group about family law reformation, you know, trying to reform the family law, you're all aware of that corruption. I can tell you, you're all aware of it because you're the victim. You've been victimized, you know. And going back to what I've said before, you know, this is actually a traumatic event for most people. I mean, I don't know who wouldn't be a traumatic event to have their kids ripped from their home, from their parents, unwarranted. And I mean that in its literal sense, unwarranted. There's no warrant to do this in accordance with their own statutes. You know, the law itself, you know, the 4th article of the Bill of Rights specifically says we're supposed to be secure in our persons, papers, and effects, our houses, the whole 9 yards. I don't really feel that secure in this country anymore, where that they can basically subvert the law statutorily and just walk all over our creator endowed rights, the law of the land, the supreme law of the land, and they can just do whatever they want. It's literally insane that these people seem to think that they can do this stuff. And these are just everyday human beings that are doing this to other human beings. It just freaking boggles my mind. How somebody in their right mind, that's the problem. I don't think they're in their right mind. All that power goes to their head and I don't know, they just get this big power, hunger, whatever it does to people, you know, in a position of power. They go nuts. They just think, well, I got all this power, I can do this. And they don't act normal. And it affects them mentally. So, yes, again, the corruption is out there. We need to talk to the correct people. We need to start informing the correct people, the people that can actually do something about it. And it starts with you, the citizen, the people. You know, Title 74, Section 201. The people of the state of Idaho do not yield their sovereignty to the agency so created. Start exercising your right to political power and start working on abolishing, reforming, you know, whatever agency it is that has a problem. And, you know, the thing is what you have to watch out for is trying to, like, the child's best interest doctrine. Okay, that is lawful. You can't attack the child's best interest doctrine itself because it is lawful. It's the process that they're doing. They're actually not following the statutes itself, but they think they are. The process that's provided, which is actually due process, the process that is due to you as a human being, is not being adhered to. So you can't attack the lawfulness of the child's best interest doctrine in and of itself. So you have to attack the state actors, and not in their official capacity, because they're not acting in their official capacity. This is where I go back to the bond. Okay, their insurance bond only covers them for accidents. Okay, not for willful disobedience to the law, disobedience, whatever. When they act outside the law, that's acting under color of law. If the authority is there statutorily or their rules or policy, then that's acting under color of authority. So the authority is there statutorily, or the agency's policy tells them that they can do this, and they do that, that's acting under authority. But if it's where the law says, you know, you're not allowed to seize anyone or arrest anyone without a warrant unless it's for a felony that happens directly in front of them, then that's acting under color of law. Anything to add there, Chris?
Yeah, as a matter of fact, I do. It goes back to, you reminded me of something I wrote that was accepted by the federal court, a few months ago. Of all basically, there was a couple things that I wrote in here, but the two things that stuck with the most was this being the first one, it does not matter what the law intends if no one is practicing the law as it was written and intended, or even worse, intentionally misrepresenting the law based on the agenda of the ones who stand to benefit from it. Now, when you combine that quote with another quote that came out of my amicus brief that went before Congress, that quote was, when an advocate's allegiances become suspect based on core concepts of law, this becomes a concern of consequence in and of itself. The relative subject matter of consequence becomes secondary with respect to facts and evidence. What that means is every time your lawyer betrays you, or you tell them, hey, do this, and they either don't do it or they do the opposite, right? That means they're not practicing the law, number one, as it's written and intended, and two, to add insult to injury, you as the paying client have an expectation of performance to with the relationship you have with your counsel. And by them not doing that, that is ineffective assistance of counsel. Where that gets ugly is, what if that counsel is the prosecutor, which is something that we're seeing all over the country. And I just had an issue with a client this afternoon. They literally tried to prosecute him for service, for providing service to a defendant. And that's why I said it's just gotten really, it's gotten to the point it's so ridiculous and stupid that there's no way that they can turn a blind eye to it anymore. The balancing mechanism since the election has already pretty much righted the ship. The problem with it is these quote unquote actors haven't stopped running around like chickens with their heads cut off, yelling and screaming, all of their frivolous, ridiculous allegations. So what we got is a bunch of people running around who are long on claim but short on evidence. And because everybody's gotten used to listening to the claim and not paying attention to the evidence, right? Because all we see on television and the news media is the claim. You don't ever see the evidence. So that's why cases like Casey Anthony, that's why cases like George Zimmerman, all of those people, you think to yourself, how the hell did these people go free? There's a dead person here. Well, did you ever think there's the possibility there's one of two things? Take the Zimmerman case, for example. It's very possible that he was defending himself exactly as Zimmerman claimed he was. And now with the way things are going, you can't walk down the street without somebody trying to run you over with a truck. Right. It's not that hard to believe anymore. So, upon reflection, you can go back to yourself and go, oh man, well, maybe that's true. Maybe the guy was just doing his job. So that's what's dangerous about listening to people who do nothing but spout off claim after claim after claim after claim, but don't back it up with any evidence. Right. So that's where you have to self-govern, right? We talk about it. It's time to preach. We preach it. It's time to practice it. Yeah. Self-govern in that, well, before you go off on somebody, maybe you should get a better look at what's going on before you jump on a bandwagon. Oh, that son of a bitch, blah, 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 because somebody else said blah, 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 blah. And that's where we are in a lot of our groups, is we jump on that claims bandwagon. Just, be careful. Don't fall into it. That's all I ask, please. So. Right.
Somebody tell you that 2 + 2 is 5, you might want to ask around. You might want to actually research the principles behind mathematics that may actually dictate a different answer. So, correct. It's don't. I don't know if anybody's ever heard of the test of 3. And just for funny, I say it's Socrates' test of 3, and it's actually Socrates, but I do it as a funny. But there's a test of 3 for when somebody tells you something. First of all, do you actually have firsthand knowledge about what you're about to tell me? Because if you don't have firsthand knowledge, well, how do you know it's true? You don't. So if you're saying that so-and-so said, and you're talking to somebody else about, well, so-and-so said, man, that's, secondhand, third hand, fourth hand. You might want to go to the source and find out for yourself instead of continuing to spread the rumor or whatever it is. But check that out. Socrates test of 3. You ever want to educate yourself on when somebody comes to try and tell you something about somebody else? Run them through that test and see what happens. You'll be rather surprised. So back to I kind of wanted to touch on one of those points that you were talking about. Basically, it boils down to jurisdiction again, which seems to be the thing that we talk about here.
A reoccurring thing.
It is, and that's the thing. If you go into a court and you demand, see, this is the thing: is we make demands because they're our rights. We have the right to demand that our rights be protected and upheld, right?
Correct.
So if we make a demand for a right to a trial by a jury, and then you are told you don't have a right to a trial by a jury in this court, you're absolutely right. That means this court is an unlawful court. Well, I wouldn't say, how about we reword that? It's not an unlawful court. We'll let them have their court. It's an unlawful jurisdiction being applied to you, because we're not supposed to be subjected to courts that don't observe our rights. And when you demand the right to be exercised, you are deprived or denied that right, then you're not in the right jurisdiction. So that's an automatic motion for dismissal with prejudice for lack of jurisdiction, for failure to state a cause of action for which relief can be granted, because no relief can be granted in this court if it doesn't have the proper jurisdiction, namely personal and subject matter jurisdiction.
And or standing.
Jurisdiction is
my favorite.
Have a right to a trial by a jury. Well, that's a bill of attainder, or bills of pains and penalties. Look those two terms up in the law dictionary. They're in the Constitution of the United States of America. Article 1, Section 9 and 10. Bills of attainder are prohibited both at the federal level and the state level. No ifs, ands, or buts. They are prohibited. And to understand what that bills of attainder are, bills of attainder were actually and they were being deprived of their right to due process of law, namely the right to a trial by jury. The same thing with misdemeanors. The misdemeanor infraction type stuff falls under bills of pains and penalties. It's a lesser punishment. And I'll go back to the felony part. It was supposed to be for death. Okay, that's what bills of attainder are. The king would send his men to seize you and say, well, you did this and we're going to sentence you to death. And you don't get a trial. You don't get to be heard. You get a couple people that say that you did this, and the king would say, put him to death. So we abolished bills of attainder, and we abolished bills of pains and penalties because they fall under bills of attainder. Now, the bills of pains and penalty, which is actually in our Declaration of Independence, it's quoted in here. These are actual declared acts of a known tyrant. Okay, the pains and penalty part is being deprived of your right to a trial by jury, because if life, liberty, property is involved, you have the right to a trial by jury. Only the jury can decide if you are deprived of any of your life, liberty, or property. Not a judge, not a CPS worker, not a social worker, not a police officer, okay? Not an administrative judge. You don't see the appellate court judges or United States District Court judges, appellate court judges, and Supreme Court judges sent in prison. take that back. The district, forget the district part, but the appellate part and the Supreme Court parts, none of them send people to prison. They're there just as oversight. But that's how they're supposed to be. Either yes,
and that's where we come into
or it's not.
The mechanism in law that provides remedy and relief for the stuff that Kirk is talking about, the word that I accidentally tripped over and knocked 230 years of dust off of it. Because that's one of the things that I said, in the initial monopoly case was, well, you can't do that. That's an emolument. And you could have, I swear to God, you could have heard an ant fart in that room.
Right.
Because they knew exactly what I was talking about, and they knew there was no way to respond. For two reasons. Number one, it had never been tested. And number two, the definition is so broad, and it's never been applied. It's like, you talk about how far and wide that one little word reaches. It's scary because its definition says any advantage, profit, or gain. Now think about that. If they're acting under the color of law, they have an advantage. They get a paycheck, so that's a profit or a gain, right?
Right.
And this is where we've literally locked horns over this word. And when it also came out that it was improperly defined in the state Congress, in not in accordance with, or up to at least the minimum standard of what the U.S. Constitution articulates it as, it was like, so what do we do now? And the answer was, well, you're going to have to sue us. And I was like, oh man, you have got to be kidding me. And
this is part of
that's how the secondary case was born. They said, okay, you obviously have the credentials. You're the only one who's ever done any kind of research or reading or work or even attempted to test it in the court. So you're the only one qualified. Have at it. It's like, oh man, so that's,
you stuck your foot in the door and they let you in, and now so
ended up and putting it in my mouth.
Right?
Shoe leather is not good, everybody, trust me. Shoe leather is horrible.
So for those that have not read the Declaration of Independence, and for those that have and forgot this part, these are the declared acts of tyrants. And I want you to listen closely, because I want you to think about what I'm saying here, because this is from 1776, okay? And I want you to compare it to what's going on today. He has erected a multitude of new offices and sent hither swarms of officers to harass our people and eat out their substance. He has kept among us in times of peace standing armies without the consent of our legislatures. He has affected to render the military independent of and superior to the civil power. He has combined with others to subject us to a jurisdiction foreign to our Constitution and unacknowledged by our laws, giving his assent to their acts of pretended legislation, for quartering large bodies of armed troops among us, for protecting them by mock trial from punishment for any murders which they should commit on the inhabitants of these states. Now here's some more here. For imposing taxes on us without our consent. Now this is the one I'm talking about right here. For depriving us in many cases of the benefits of trial by jury. This is a declared act of tyranny.
Correct.
It's 1776. Let me read that again. For depriving us in many cases of the benefits of trial by jury. This is why we put bills of attainder are prohibited both at the state and federal. Article 1, Section 9, and Section 10 of the Constitution of the United States of America. Bills of attainder are prohibited because of that. Right there. That's why that wording is in the Constitution. for depriving us in many cases of the benefits of trial by jury. In most cases, and that's what we're facing today. In most cases, we don't have the right to a trial by jury anymore. We have the right, but they're not allowing us to exercise that right. I hear it all the time. Well, I've got to go to court to, oh, well, did you demand your right to a trial by jury? Well, they told me I don't have the right to one. Okay, well, we got a problem here. But you need to address that. Address the jurisdiction.
Yep, and that's where a federal tort comes in, because you can state that the state has fallen below its mandatory standard, right, to remain in compliance, to maintain its membership with the Republic of the United States. I mean, it's a simple claim. So by denying you that fundamental right under the, under both our due process clause and the Declaration of Independence itself, those two documents alone, you can sue your state's Congress or your county or whoever, whoever is at that state level for deprivation of right. And that's in federal court. That's the proper venue or proper jurisdiction, basically telling the federal government, hey, this state has dropped below its minimum requirements to maintain its membership to the Republic of the United States. Cut off its federal funding. There's a good place to start. That's Trump's favorite thing to do.
Right.
And mine personally. So, that's where, you want to hit them in their wallet. That'll hit them where they live.
Every time. So back to these more declared acts of tyrants, for abolishing the free system of English laws in a neighboring province, establishing therein an arbitrary government and enlarging its boundaries, so as to render it at once an example and fit instrument for introducing the same absolute rule into these colonies. Now, if you understand what that's actually talking about there, enlarging its boundaries so as to render it at once an example and fit instrument for introducing the same absolute rule into these colonies. What absolute rule are they talking about? They're talking about admiralty jurisdiction, maritime law. And I can take you back to the Declaration for the Necessity of Taking Up Arms, where they specifically say that. And that's July 6th, 1775. Okay, that was the necessity of taking up arms, or also known as the Declaration of Arms. Reason why we took up arms was because they were trying this right here, right there. That exact reason right there. All of these reasons to be exact, but for taking away our charters, abolishing our most valuable laws, and altering fundamentally the forms of our government. Imagine that. Altering fundamentally our form of government. And what we're talking about here is our Republican form of government, which the Constitution says is guaranteed to every state in Article 4, Section 4. Period. It's guaranteed a Republican form of government, not a democracy. We are not a democracy. We are Republican. By the public, we are self-governed. Our rights cannot be put to a vote. You have the right to a trial by jury. You cannot put that right to a vote by congressional act or otherwise, statutory law, through legislation. Well, we're going to create, this is back to the extending this admiralty jurisdiction back onto the land so they can get away with these bills of attainder and bills of pains and penalties and apply this maritime law, the law of contracts, and the law of the sea, which says you don't have the right to a trial by jury anymore. You're in the wrong court, and you have to object to that jurisdiction, plain and simple. And I don't care if they deny that. You have to assert that. You have to make the claim that this jurisdiction doesn't apply to me. And you let them do whatever they want, and then you go with what Chris was saying. It's the second they deny you your rights, that creates a right to a cause of action for you to take it to federal court, depending on where it's at. And what, Title 32, Section 1983 is civil rights, deprivation of civil rights. But there's other ways to file stuff. There's 1985, 1986. There's other things that give you a right to a cause of action as well. And I don't know what all those are, but there is plenty of things within the code, the federal code, because you're talking federal crimes when you're talking about being deprived of your rights. That creates that right to a cause of action and seeking remedy, because that's what it's all supposed to be about, is seeking a remedy to stop what's happening to you and to fix it, or claim damages. That's the tort claims. Okay? I claim deprivation of my right of liberty, and that's $250,000 per instant. I've got 5 different instances. We're talking $1.25 million. That man owes me for depriving me of my rights. That's the damage.
Which is where we go to stating your claim. Okay.
Right.
And this is where it gets real tricky, because people start tripping over this thing I like to call the soapbox, right? Well, blah, 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 blah. And the visual I get in my head is a monster truck stuck in a mud bog. Now, follow me through here. You got this big truck stuck in a mud bog, and you punch the gas pedal to the floor. What's going to happen? You're going to get filthy. I mean, that truck ain't going anywhere. You're stuck.
Yeah.
What you got to do is you got to ease your way into it. Granny gear, ease your way into that sucker. Just touch the throttle. And that's what I mean by stating your claim. Just touch the throttle. On this date, this happened. Next point, on this date, this happened. And so on and so forth. Even if you end up with 100 bullet points, okay, don't number them, bullet point them. Because what you've done is you've effectively told a story through bullet points in chronological order, and that is how you effectively state a claim. Okay? So instead of just running off at the mouth, and even the judge goes, oh my God, I think I'm going to kill myself. You're not going to get anywhere that way. I'll be the first one to tell you, even having been through this myself, I can tell you from personal experience, never gonna happen. Choose your battles, right?
Right.
You can say, well, this and this and this and this. Do you have documents to back that up? Right? So yeah, you might let 1 or 2 incidents or 5 or 6 incidents or however many incidents go. Choose your battles. All you got to do is show, number one, where the wheels came off of the wagon, right? Yeah. And if that's at the beginning, the rest of the stuff only makes the situation that much more egregious. You don't need every single little detail, right? All you need is just enough that makes your story more not only believable, but plausible based on the evidence that you've provided. So that's where those two things fit together, your statement of claim with your evidence that supports what you just said, right? So you say, on this date, this happened, and so is this your signature? Yes, it is. Can you explain this document? It's simple. And that's another problem. They run into this a lot because they're just so pissed and they just want to reach out and punch someone. Mm-hmm. And guess what? You're not the only one.
It's serious frustration.
Every one of us wants to just line them all up and just.
Yes, it's serious frustration. You know what your rights are. You know how you're supposed to be treated, and someone doesn't. So actually,
and the more and this is the best part. The less you throw at them, the louder they're going to get, and now they start to sound like the monster truck flinging mud everywhere.
Right.
You're standing there looking at the judge like dumbfounded. The judge is sitting there looking at you dumbfounded. The jury's just standing there looking at everybody going, what the hell are we supposed to do about this?
If you got it,
right? Yeah, if you're lucky enough to get one. But I mean, even if just between you and the judge, all you got to do is just keep your cool, man. That's it. You keep your cool and show respect to the court, even in the face of adversity.
Yes.
Guess what that does to the credibility of the other side? What credibility?
That's why I go back to make your statements. Okay, make your claims, make your statements, make them short, make them sweet, be respectful, and shut up. Don't let you emotionally. Don't have an emotional response. But here I go, I might have one. CJ Abernathy says, I claim you are preaching constitutional rights while working with someone that deprives rights of speech. You talking about like President Trump, or who are you talking about there? Because that's exactly what we're talking about. We don't have constitutional rights. We have constitutionally protected rights. We have creator endowed rights. We have unalienable or unalienable rights. So I'm not sure what you're actually talking about there, CJ. But if you think you can come on to somebody else's show and that you have the right to freedom of speech and talk, you're mistaken. You can't exercise a right over the top of somebody else's right. So, for instance, right now, this is my show. I'm allowing Chris Hallett to come on to my show. I'm allowing Ted Fogg to be on here. Obviously, I'm allowing Ted Fogg because he's promoting it. So I'm not depriving you of going out there to exercise your right of freedom of speech. You go right ahead. You go do your own show, and you have the right to exercise your right to freedom of speech. But just because you have the right to exercise the right to freedom of speech doesn't give you the right to exercise it over the top of my right. And my right to refuse you on my show. Because that's how my right works. My right doesn't say that I have to let you talk on my show. Period. This is my show. My property. I'm exercising my rights. And your rights don't trump my rights. They don't go over the top of my rights. So, no, I'm not depriving anyone of their right to freedom of speech. And I'm not preaching constitutional rights. I'm preaching creator endowed rights. That's what I'm preaching. I'm preaching the law, what the law says. Not a whole lot of opinion here, just what the law says. I mean, we do have our own opinions every once in a while, but the law says what it says, period.
Right. It's interesting, too. We talk about the difference between laws and statutes. You touched on something a couple of weeks ago that, believe it or not, has actually turned into a federal question with me. I started to talk about this a little bit last week, and statutes that cannot exist in law for the simple reason the subject matter relevant to the statute has already been tested and declined by the federal court. And give you, for example, the practice of law. That question was decided back in, I think it was 1973, was the Sims v. Aarons case. Would you believe every single state has an unauthorized practice of law statute? Now, my question is, knowing that the practice of law is a right retained by the people, who's the one authorizing it? And everybody's kind of standing around looking at each other going, well, it wasn't me. So then, basically, why is my client standing here being tried for a crime that cannot exist in law? And, literally, here we go again, having to prosecute the prosecutor. I get tired of repeating myself, but, as many times as it takes to get my point across, I'm prepared to do that. So, yeah. And that's the case right here in Florida. And the brief is probably about, a third of the way done now, but the simple fact of the matter is, it's a good question, and the federal court is not happy about having to answer that question again, because as far as they're concerned, hey, look, we made our peace. We said what this is. What are you doing? And now, like I said, everybody's kind of like standing there staring at each other going, So you're going to run into this a lot when you're talking about law versus statute. So if they charge you with a statute and you find out that there's a case that statute was already tested and the statute failed, you just say, hey, this is res judicata. You can't try me for this. It's already been, this went to the Supreme Court, and the Supreme Court said you can't do this. So why are we having this conversation? Motion to dismiss for lack of personal jurisdiction. You're out of here. Bye. It's just, it's that simple. Keep it simple.
Keep it
and
simple.
The courts appreciate that, by the way. They really do.
Yeah, they do. Short and sweet. Questions of facts of law. That's what they deal with. Questions of facts of law. The jury deals with questions of facts of evidence and guilt.
Right.
That's the problem we have, is we have the judges who are assuming the powers of both. So if there's a way, there's a way to demand, letter of demand. I demand my right to a trial by jury be preserved here. I want to exercise my right to a trial by jury. So, letter of demand in the beginning of your case. And if they deny that, well, obviously you're in the wrong jurisdiction. You need to make a motion for dismissal. If they grant it to you, then go with it. Go with the trial by jury, even if you know you're in the wrong court and you've made the objection. But again, you have to speak up. You can't sit over here in the corner on Facebook or Twitter or YouTube or wherever and claim foul without saying something to the appropriate people. You're responsible for asserting your claims, asserting your rights, demanding your rights be upheld and observed, because that's a moral duty and ethical obligation to your fellow man to respect your rights. It's a moral duty. Seriously, it's a duty. You understand what duty means? You're required by law, morally and ethically, to respect that right. The other
right. And there is a maxim of law that clearly states, law is the science of what is good and just.
Mm-hmm.
So if you can apply a science to a law, using my own example just for sake of simplicity, that is something that's recognizable by the court. They can take that thing and go, hell, I can use this over here. I can use it here, 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 and here. And what you've just done is you have provided a service to the court, right? So instead of just standing there yelling and complaining and screaming and pissing and moaning and whining and crying, give them a solution that fixes the problem. And I'm not talking about, well, throw that son of a bitch in jail. That's not a solution.
No.
Okay, that's a punishment. That's a whole different animal. A solution is something that can be used over and over and over and over and over again. As far as what's reasonable, you make a suggestion or a recommendation based on history, and make sure your history is accurate, because they will check. And if your history is accurate, your request will be deemed reasonable. It's not complicated, and it's all how you come out and come across to people. If you want to be respected, show that respect.
Right.
And it's strange that, in these lower courts that are administrative courts or parliamentary practices, as I call them, personally, I wouldn't let my dog pee on those. But as far as an actual court of law, like a federal court or an Article III court, that's a whole different animal. You know, like Kirk said, if you walk in and you look at the flag and the flag does not have the gold fringe around it, that's a court of law. That's the one that deserves your respect.
So this person, Neely Blanchard, I did all this letter of demand and a motion to dismiss. They still don't do it. That's exactly the point I'm talking about. But you have to do that, okay? That establishes documentation that you afforded them the opportunity, because due process of law is notice and opportunity to be heard, okay? So you put them on notice and they don't, you know, okay, let's say they allow you to be heard, and you make your oral argument for your motion for dismissal for lack of jurisdiction, and they deny that. Now listen carefully. When they deny you your rights that you have made a demand on, that is an usurpation of power. That is a deprivation of rights. That automatically creates a right to a cause of action, an independent right to a cause of action. Okay? Not in the same court that you're in. That's what independent means. A separate cause of action. Okay? That gives you standing to bring a cause of action against the usurper in federal court for deprivation of rights, civil rights. Okay? So I don't care what they do. You have to file your paperwork. You have to make your arguments when allowed. You know, if they deny you flat out to be heard, well, that's still a deprivation of a right, and that creates the right to a cause of action. But again,
that's a simple 1983.
Right. If you sit back here on your haunches and complain, well, I filed that and they just denied it. Okay, what did you do from there? You know, it's like the schoolyard bully comes up and slaps you in the face and you say, look, stop that. That's not right. Don't do that again. Okay. And
he's going to do it again.
And he socks you again and you don't do anything about it. Whose fault is that?
So the correct response here would be either a notice of appeal or a notice of federal removal, or both. You can always do both, because the Federal Tort Supplement clearly says you do not have to exhaust all state levels of relief and all paths to relief and remedy before you file a tort. Now, lawyers will tell you otherwise. I can tell you now, I know different, because I've got three cases, including my own, that's exactly what's going on. We're arguing in multiple courts.
Right.
So, you know, it's and every state has what's called a judicial panel, which you can actually call all of those judges to the panel. Here's the problem. The lower court admiralty judges, or administrative or parliamentary practice judges, call them whatever you will, they end up getting put in the headlights, right? Basically, you know, here's what's going on in that room. What in the hell are you doing? And, you know, the answer is, well, under the statute, blah, 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 blah. Well, okay, that's the statute, but the law says something else.
Right.
The evidence says something else. So you've misapplied the law. Well, I didn't do that. The prosecutor did that. Did you discipline the prosecutor? Well, no, and I can't discipline the prosecutor until somebody asks me to. Aha! Therein lies the problem. If you don't ask for the disciplinary or the sanction, guess what? The judge can't do it. If the judge is the one who's guilty of the offense, then there's Ulrich versus Butler. We've already answered that question. When a judicial entity is committing an action that is not a judicial function, it is a personal action, not a judicial action. There's no remedy there. The judge does not have immunity. So, and right. That's where it gets tricky.
The of independence also removes his judicial immunity.
I'm sorry?
Owens versus City of Independence.
Yes, that's another one. Yes.
Judicial immunity, all immunity from anybody. Nobody
Right.
is above the law, period.
Right. In other words, they can't claim good faith if they're trespassing against the law.
Right.
That was actually the decision in Owen versus City of Independence, because that was the question.
Mm-hmm.
So, again, like emoluments, that is actually a it's got a farther reaching means of relief and remedy than like Ulrich versus Butler. That one was the case where the guy wanted to bring a recording device into the courtroom, and they told him he wasn't allowed. Supreme Court said, yes, you are. So that's basically the difference. But
I wanted to comment back to Neely. He or she, I can't really tell. She's like, I'm sorry, I'm trying to understand. Right. Hundreds of thousands of people trying to understand the same thing, because she apparently got threatened. He or she, I don't know. I can't see. It's super small. So I just got off probation, and they said they would put me in jail if I filed anything else. That's fear tactics. Again, let's go back to trying to keep it simple so people can grasp this real easy. The schoolyard bully socks you in the face. You go and you talk to the principal or the playground teacher aide, whoever's watching the playground, and say, hey, the schoolyard bully over here just socked me in the face. And they don't do anything. They are now culpable because you have told them, and their specific job is to watch the playground and ensure safety of the children on the playground. So if they don't, again, they don't have any immunity to deprive you of your right of being safety, because that's their duty, okay, to protect the innocent. And then you take it to the principal, and the principal doesn't do anything. Well, guess what? You keep going up the line. So when we're talking with going to this United States Supreme Court, going into an actual court of law, Title 42, Section 1983 deals with civil rights violations. Well, it deals with more than just civil rights. It deals with deprivation of rights. So it's a lot broader than just civil rights, right?
Absolutely.
Right. So anytime you make a claim,
I'm looking for the statute.
Right to exercise a right, such as the right to a trial by jury, the right to due process of law, the right to be secure in your person, papers, houses, and effects, and that's been deprived, not violated. Don't use violated. It's deprived. You've been deprived of your security. To be secure in your person, places, houses, effects, papers, everything, without a warrant. There has to be a warrant, because that's what it says. No warrant,
right, and there's
but upon probable cause. That probable cause is actually a right to a cause of action. That probable cause of action, and that has to be that. And part of the Fourth Amendment specifically says supported by an affidavit. This is the very beginning of every single case. Affidavit of truth must be signed under penalty of perjury, which gives one man the standing to a right to a cause of action. Without that affidavit, you can't get a warrant. And if you can't get a warrant, you can't come onto somebody's property and seize or search anything. There's no lawful authority to do that. And the only way to make an arrest without a warrant is it has to be a felony happening directly in front of you. And I don't care who it is, police officer or another man. You can't make an arrest without a warrant unless that felony is happening directly in front of you.
Right. Now,
or a breach of
getting back to her question, what would be two applicable statutes to her example? The first one is breach of fiduciary duty under 29 USC subsection 1109. basically in that this person has a duty to be a mandatory reporter to report to the appropriate authorities to basically stop that trespass, right? And if the person that you report it to violates their position and doesn't report it accordingly, that person is liable under the statute. Now, if there is, for example, when you're talking about litigators, such as lawyers, which are my favorite people I like to sue, you're talking about vexatious litigation, which is, you know, remember when I started using the example of they sound like the monster truck and they're flinging mud everywhere, right? Yeah. That's vexatious litigation on its face. And right. That's punishable under the law, 28 U.S. Code, subsection 1927. Okay? So, it's one thing to make a claim, but is the event that you're talking about have an available relief and remedy in law? Okay? And the answer to that question is yes. But if you don't bring it to the judge or to the court or the appropriate authority correctly, right, you're going to be the one stuck in the mud. Yep. And here was my problem with this. They've made this process so ridiculous and overly cumbersome. We're right back where we started 230 years ago, right?
Yep.
So, you know, in my principles and practices of loss prevention, I said, hey, wait a minute. If we can't do this in the private sector, you sure as hell can't do it in the public sector. And the court went, wait, what? Show me that again. How does that work? So I said, oh boy, here we go. You know,
right.
When they start asking you basic questions like, what is loss prevention? Yeah, they're kind of out of touch. So, you know, and again, it's how you answer the question. If they're going to open a dialogue with you and they're going to ask you a question, for the love of God, be clear, be concise, be respectful, and answer the question the best you possibly can, as clearly and concisely as you possibly can.
Right.
Because your chances to speak directly to the judge are few and far between. And they will remember you. If you're the one who was kind and respectful and paid the court its due attention and its due respect, you're the first one they want to hear from next time. Mm-hmm. They're going to tell everybody else, you know what? I don't care what you say about this guy. Not in my courtroom it has. I've never seen that. I got no evidence that shows me that. So what are you talking about? And like I said, that's when they start. That's when they start. You know, well, blah 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 blah, and there goes the mud flinging everywhere. So that's how you literally reverse it on them, and it's not that hard to do. Yeah, it's hard to suck it up. I'll be the first one to say you don't want to reach over there and punch him in the mouth, but you can't. I mean, let's just face it. You know, you can't do that either. So yeah, you can do the next best thing.
Some restraint. But
yeah,
be respectful and stuff. If they're asking you questions, if the judges are asking you questions, I mean, obviously you can tell the difference between judge being a jerk, but you know, sometimes you'll get a good judge that's like, well, wait a minute, I actually have a legitimate question here. And if you snap at them and think snarky comments and, a snarky answer do you good, it's not. So, and especially if you go into like the appellate court or your state supreme, even the state appellate court, state supreme court, I'm telling you, I went down October 24th to our Idaho Supreme Court, and I sat in on an appeals hearing, 3 judges up there, and it was a totally different atmosphere. And again, there was no gold fringe on the American flag. So that tells me I'm in a court of law. And this is Idaho Appellate Court, okay, at the Supreme Court. And the attitude of the judges was totally different than I've ever seen. I mean, it was freaking awesome. Let me tell you, there's some hope out there. So again, this goes back to the first initial court that you go into is the Admiralty courts. Okay, they're designed to chew you up, run you through the machine, and just ring you for all the money they can get out of you. And
that's right, meat grinder, baby, meat grinder.
Right, and spit you out the other side and put you back out there so you can go make some more money so they can charge you with something else. But the man who stands up and is the belligerent man and stands on his rights, claims his rights, demands his rights, the squeaky wheel gets the grease. So eventually you take it to the appellate court. And the appellate court's going to look at that and go, what's going on down there? Okay.
Right. And that's where we are now in the case law, in the cases I'm working personally, is those conversations, believe it or not, are happening right now. The higher judges are calling the lower court judges going, dude, what in the hell are you doing?
Right. So this goes right back to filing your paperwork, making your claims, because, see, this is what happens when you go to the appellate court. The appellate court demands a copy of the transcripts from your hearings. Okay, whichever hearing that you're appealing, whatever decision that you're objecting to, because that's what it is, the decision of the court, you're objecting to that decision. Whether your motion for dismissal, whatever, your motion to suppress unlawfully obtained, illegally obtained evidence, which should fall under the fruits of a poisonous tree doctrine, okay, and they deny you your rights, okay, you're objecting to that decision, and that all is appealable issues. So at the end of the case, when you get your final judgment, or even just the judgment on that particular hearing, okay, you have the right to appeal that. And you take that to the appellate court. But the thing is, I really need to put this out there, is don't be scared. Don't be scared to make your claims in that precedent court you go into. You want to get everything in and on the record. You create your that record, okay? So when you do appeal, when you do go to federal court, that's all there. And so the judges look at that and go, what the heck are you guys doing down there? He made his claims. He demanded his rights, and you deprived him of his rights.
Right.
They're the ones that
Here's another thing that higher court judges look for. Let me give you a nickel's worth of free advice. Here's another thing that higher court judges look for. If you use the F word like a comma, don't expect any respect in any higher courts.
Right.
Dude, I'm serious. I have seen transcripts that litigants do that. Whether they realize they're doing it or not, I don't know. But when it says explicitive or some other form other than the word that was spoken in the transcript, the judge basically sets the tone of hostility, basically, in that the person who was speaking at that moment was probably hostile. If they're mad enough to swear, and if they're dropping F-bombs like commas, that's not somebody I want in my courtroom. Nope.
Right.
Denied. Yep. Right? And it's their courtroom. They have the right to do that. So, again, that's why I said it goes back to that level of respect. If you want it, show it. And it ain't right. It's when you come out of the other side of that thing on a meat grind, like a meat grinder, but you can stand there whole. They're looking at you like, we got nothing on this one. we threw the book at this one, and we can't make this one break. And now they know they've got a serious problem. So it's the ones who make it through the meat grinder that don't collapse under the weight of it. Mm-hmm. And that's what's going to make or break you.
Right. So it's all about making your statements, getting your paperwork in and on the record. You must be respectful. All of that's going to come back on you. You have to be in control of yourself. And then again, if you can't afford the copy of the transcripts, which is so crazy, but this goes back to the Magna Carta of 1215, number 40. We will sell to no man. We will not deny nor defer justice or rights. That's just the law. It's the way it is. So
well, in criminal cases, the transcripts are free anyway. Yeah.
It's called informal
criminal cases.
Okay. So
right.
If you can't afford to pay the filing fees for your appeal, informa pauperis. Obviously, if you can't afford to defend yourself to begin with, you should have already filed for an informa pauperis. Okay.
Right.
But if you have the money, to pay the filing fees, I highly suggest it. Just pay it.
Absolutely.
Because they will take it on. I mean, just like, well, that you paid. Okay, well, let's hear this. They're going to be a little more hesitant with the informa pauperis, but if you can afford to pay for the appeal, which is usually a couple $100 for the appeal. If you go to federal court, it's $400.
No, the federal tort's $400. The federal appeal is $505.
But I'm talking about starting your own independent action under Title 42 is $400 side.
Right. Exactly. Mm-hmm.
But if you could afford to pay that, do it, because it's weird how it works. If you pay, you get hurt. You do the informa pauperis, you may or may not get hurt. But
right.
I mean, if you
here's a little known seldom used tool. If you pay that $400 in the federal court, guess what? You don't have to pay to the state court any more fees, because the federal court will say, "Hey, state court, we want the transcripts, we want all the evidence, we want the blah 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 blah," and the state court knows it has to oblige the federal court. When the federal court makes a request, there ain't no saying no. So instead of paying $1,200, $1,300, $1,400 for a transcript in state court, if you remove the federal court, you can pay the $400 and kind of save yourself a few bucks there. Just like I said, little known, seldom used.
Neely asked about the Magna Carta. Magna Carta of 1215 is the great charter of liberty for all English-speaking people. Okay, it's in full force and effect today. There are certain provisions that apply to us in America, because that's the common law of England. So the common law of England is in full force and effect so long as it's not repugnant to the Constitution, because we are English-speaking people. That's where we came from. 1608, somewhere in there. 1608, Jamestown, Virginia was established. It came from England over to Virginia, Jamestown, Virginia, and established Virginia. We brought lots of money, lots of royalty, and we brought the Magna Carta over here, the common law of England. That's how it got here. So that's it, just in our history. But there's other revisions, the 1225 revision, which goes into chapter 29, which is the same as 40, but it's been reworded a little bit, which that's called succession of law. That's just how things are. But the first instance that it's been established in law is what it means. And as it goes through succession of law, it may change the words, but what you do is you look at every single one of those, and all of them are still lawful. They're all just declaring the right the same. They're not allowed to change the meaning. They can further expound on it. Through succession of law, rights do not change. That's why the Ninth Amendment says, shall not be denied or disparaged. Okay?
Right. Law, and remember, you're talking about a court of law.
Or disparaged.
Right. And when you're in federal court, which is a court of law, this is the stuff you argue. When you're in an admiralty court, the court of admiralty, the statutes is the stuff you argue. So, for example, when you go and you file your federal tort, they don't want to hear a bunch of state statutes. They want to hear how the circumstance, the thing you're talking about, applies in law, right? So they want to apply a federal law to it. So that's the difference. That's another thing people get confused about. The difference between the state and the federal levels is when you're at state level, you're talking statutes, which is all the meat grinder crap that they throw at you. The state of Florida's is 716 pages, I think, as it is right now. And the federal statutes and the federal laws is literally a fraction of that. So one of the things that I've asked is, why is it that we need, the state of Florida needs 716 pages of crap that the federal government can manage in a fraction of that? And you're going to tell me that's not a waste? You know, that's why I said it's not just how you ask the question, it's the substance of the question. You know, lawyers, how many lawyers out there can say they know all 716 pages of that? None of them. None of them. It's impossible.
Right.
That's overly burdensome. Right. And that's another thing, you know, you can basically state that, you know, look, if you're talking about the statutes, you know, you walk in there with a printout of 716 pages. This thing looks like a binder. You say, is this the stuff you want me to know all of this just to live here? Dude, you're out of your mind. You know, and it's, you know, that's the kind of stuff you want to make them think. Put it in front of them. That'll make them think a little bit. And, you know, it's hilarious to watch these light bulbs come on, because you think there's no way there's just no way I witnessed this. You know,
right?
This person's been doing this for how long, and they claim they've been doing this for how long. But I walked in the room, asked a couple, 2-3 questions, and all I see is deer in the headlights here.
Right.
So it's like, yeah, okay. I think I know where this problem is. So, and that's when you start talking about solutions.
Yeah.
And that's the stuff that if you can give a solution to a judge that's easy and it's something they can apply, like motion to dismiss, you know, just for sake of argument, yeah, give them an out. The last thing a judge wants to do is apply the law to a bad case.
Right.
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 So if you can get them to dismiss the case, to talk them right into it. So, you know, and that's ironically one of the things that I know I'm going to end up doing is I'm going to be the first for-profit corporation whose sole purpose is to not make money. So, you know, talk about the conundrum. This whole situation is full of them, believe me. And that's what I talk about, what's reasonable, you know, when you talk about reasonable attorney's fees. And one of my clients just got a bill, it was like, I don't know, it was almost like 20 grand. It was ridiculously stupid. And you're going to tell me that for this, you know, how many hours a week did you really put into this thing? You know, 7, 8 on average, once every couple, 2-3 weeks, you put 7 or 8 hours that week into this, and you say you're worth 20 grand? No. I don't think so. I mean, the state Congress sets minimum wage at what? So, $7.25. You know, yeah, exactly. So you're going to tell me you're worth how many times more than the minimum wage?
Right.
When you haven't put a fraction of that amount of time into that? I mean, let's do the math here. Let's look at this from a reasonable standpoint. Yeah.
Right.
So, you know, when it comes to impeaching a bill, you can make them drop the bill. All you got to do is just say, dude, are you serious? You know, I mean, is your office gold plated? I mean, you know, how do you justify this when you're talking about, I mean, how many real hours did you put into this thing?
Right.
And, you know, I watched this happen once. I mean, even the judge said, yeah, come on, dude. You know, really? That's a little excessive, don't you think? And they did end up negotiating, and the guy wrote the check right then and there, paid it, and it was done.
Yeah.
So it's all in how you address the situation. And that's the best advice I could give anybody. Just be reasonable, even though they're trying to get you not to be.
So I'm going to switch gears here because this seems to be a growing problem. People are getting charged with failing to pay child support, and they're trying to put them in jail. Jay Moss is actually going through this, and I'm actually working on putting some stuff together, not necessarily for him, but I'm going to definitely pass it on to him. Going back to that bills of attainder is one thing. They like to claim that it's not a debt. Okay, so lawful notification letter. Okay, if this isn't a debt, pull out a dollar bill, $5 bill, $20 bill, whatever you got. Read what it says on there. This note is for debt purposes, you know, pay debts. Okay, so if they want to claim that you owe this money and it's not a debt, how do they expect you to pay that? Pay it with what? Because the promissory note, these are good. This is legal tender for all debts. I'm not going to pay you with this because this is only good for debts. And if you're going to claim it's not a debt so that you can throw me in jail, well, what are you wanting here as relief?
Right.
You want me to?
Because the notes all say this note is legal tender for all debts, public and private.
Right.
I mean, that's what it's literally written on every bill.
So it has to be declared a debt.
Right. And debtors' prisons were abolished. So, again, play on words with them. They love those.
Oh, yeah. So, and then, see, now here's the problem I'm having with my phone. Facebook is running over here trying to follow the comments, but I only get about two or three of the comments. And my Facebook completely just shuts off, goes right to the home screen.
Yeah, I quit using my tablet. I actually had to go back to the old PC.
So, aside from the bills of attainder, bills of pains and penalties, those are things that you can bring up. Your demand for a right to a trial by a jury, and then, of course, excessive. There shall be no debt or no imprisonment for debt. Okay. Those are all things that you can bring up. And what I mean by bring up, put in your paperwork. Because they have to answer your paperwork. And anything that has not been rebutted stands as truth. Is this not a debt? Well, if it's not a debt, then what is it? And if you're going to say it's a debt, then no imprisonment for debt. But I know that what they try to pull on people is, oh, well, this isn't a debt. This is support. Okay, how? What is support? What are you asking? Right. Well, you have to pay that. Pay what? Well, you have to pay this support. With what? With money. Oh, but you just said it wasn't a debt because this is only good.
Do you have an idea how mad they got at me when I went this round robin with them? Because you know me being me. Oh, I had to do it. I just couldn't resist.
Well, you know, there's actually there's a case out there, Montgomery Ward versus was it Eugene something? And this is not exactly the way he did it, but his wife went out and bought stuff on a credit card. And then he went to court and said, well, look, I don't even know about this. I don't know she bought this stuff. Well, isn't this your wife? And, yeah. So, okay, you owe the debt. Okay, well, how much? Okay, well, okay. You owe this amount of money. Okay, amount of what? because they abolished the gold and silver. Okay, even though the Constitution says gold and silver shall be the fixed weights and measures and the standard that we all go by. So if they abolish that, then what actually we do? Well, we've got these Federal Reserve notes, promissory notes, debt notes. Okay, but if the court tells you, and this is what happened in the case, it's like, okay, well, you owe, $5,000. $5,000 of what? If I ask you for 5 pounds, you're going to go 5 pounds of what? Well, 5 pounds of sugar, or 5 pounds of flour.
Nicholas Herring brings up an interesting question here.
Right.
He says,
they're Homer Simpson dope moment, and he said, "I don't care what you pay him with coffee beans," and he had his dope. Okay, so this is the case. The gentleman went down to the store, and basically 1 for 1 coffee bean per $1. And he paid Montgomery Ward in coffee beans. No joke. So, they want to do a play on words.
I don't know who that guy is, but I like his style.
I'm standing on the spot. You get him. Don't take no for answer and put him in the pickle just like they do to you. Can't put me in jail because that's debtor's prison. But then you're going to claim that it's not a debt. Well, what are you expecting me to pay it with? I mean, it's not a debt, so it's not a payment thing, but you're saying I owe this whatever amount it is. Well, you owe $200, or we're going to put you in. Well, usually it's more than that.
Mm-hmm.
But,
right.
Whatever that sum is, you owe this in dollars. Dollars of what? Generally speaking, you say this here $1 bill, you need 200 of these to pay this. Pay what? You're not saying it's a debt, so what am I paying?
Yeah.
And again,
right.
Back to that.
Exactly. I don't need you to tell me, Mr. or Mrs. Judge or whoever you are, that I need to support my kids. I knew that when I brought them into the world. Thank you, Captain Obvious.
Well, so the thing
again,
is what are
you here to tell me?
Support is love, care, and nurturing. Support is not monetary. It's been construed. We're being told
that depends who you're talking to.
Monetary. Support is love, care, and nurturing. Instruction.
Right. Nick Herring says, bring them coupons.
you know that camp sag that supports your shelf in your closet? That's a support. There's no monetary gain to that shelf by having that support there. It upholds the shelf. It supports your child. You support your child. Money doesn't support the child.
Right.
Love, care, and nurturing supports your child. But again, here's the word game. They redefined what support is.
Right. And Nick also brings up an interesting point too, where he talks about where they hold you in contempt in the Admiralty jurisdiction. And he's right. That's a loophole that they've created. So, again, there's another challenge, right? You're going to hold me in contempt for what? Was I disrespectful? Did I call out your mom? I mean, did I say something about your sister? I mean, what am I in contempt of?
Right.
Oh, for not paying this debt? Do you want to go that round robin again? You back them into a corner enough times and they'll figure out that their loopholes are not exactly loopholes the way they think they are. So you become less attractive because you are now a waste of the court's time for 2 reasons. Number one, they can't trip you up. And number 2, they don't want you teaching the 50 people sitting behind you exactly how to do this. Because what's going to happen is the next guy's going to come up and go, whatever that dude did, I'm doing that.
I don't know everything about what he just said, but I'm similarly situated here, and I'm on the same charge as him and what he said.
That's right.
actually happen. And the judge
Yeah,
says,
it does happen.
here for this same crime, alleged crime, or who's here for these same charges, and the judge dismisses them all.
Right.
Because when one does it, it protects the rest of us.
Well, here was another question I asked, and I was literally thrown out of the court and told not to come back, was this statute that you're talking about is what's the intended purpose of the statute? I get the confused dog face, where they tilt their head to the side, right? Say, well, is the intent of the statute to punish, or is the intent of the statute to deter? Because if the intent of the statute is to punish, that statute cannot exist in law because the United States system of justice, its intended purpose is to deter crime, not punish crime. So that was the part where they threw me out the door. Don't ever come back here.
I actually have American jurisprudence right here that I've been saving here, trying to figure out how to squeeze this in, and now right here. This is American jurisprudence, volume 16, Constitutional Law, section 100 of Constitutional Law section in volume 16. A constitution is usually a declaration of principles of the fundamental law, many of its provisions being only commands to the legislature to enact laws to carry out the purposes of the framers of the Constitution, or mere restrictions upon the power of the legislature to pass laws. However, it is entirely within the power of those who establish and adopt the Constitution to make any of its provisions self-executing, that is, operative without any necessity for further legislation. Yeah, there's some pretty damn good stuff. Like, here you go, observation. Even without the benefit of a declaration that they are self-executing, constitutional provisions in, now listen closely, constitutional provisions in bills of rights, that's plural, bills of rights, and those merely declaratory of the common law are usually considered self-executing, as are provisions which specifically prohibit particular conduct. Okay, so right there we're talking about bills of rights, which I talk about the Virginia Declaration of Rights. That's actually a Bill of Rights, and I actually have that open right here out of my Annals of Congress, or Annals of America. This happens to be Volume 2 out of my 21-volume set, missing Volume 1. And this says right here, as the theoretical foundation of all government. Oops. The Virginia Declaration of Rights as a Bill of Rights happens to be the theoretical foundation of all governments, because the Virginia Declaration of Rights, okay, this is June 12th, 1776. See, this is things that people don't quite understand out there, is we actually have 4 documents. 4. The Declaration for the Necessity of Taking Up Arms, that was July 6, 1775. Then we have the Virginia Declaration of Rights, June 12, 1776. Then we have, wait for it, the Virginia Constitution, 1776, which was actually at the same time, I believe. I thought it was the same time as the Declaration of Independence, but it isn't, because if you actually read the Virginia Constitution, part of the Declaration of Independence is in the Virginia Constitution. So those 4 documents actually go all together. The Declaration of Independence.
Right.
All of them. So there's the Bills of Rights that American jurisprudence, which is the American conscience of the law, the science behind the law. So going back to tying that into what you were talking about, science of the law.
Right.
This is it.
That's
right here. The common law.
Right.
These rights are the common law.
Right. Now, when we talk about solutions to give a judge, here's a good one. Everybody knows about judicial canons. Here's one in the book. I don't know if you got a Black's Law. I'm looking at 10th edition, page 377. The constitutional doubt canon. Okay. This is the doctrine that a statute should be interpreted in a way that avoids placing its constitutionality in doubt. So in other words, if the prosecutor says the intended purpose of this statute is to punish, that places its constitutionality in doubt.
Correct.
Right? That means that statute cannot exist in law because the law's intention is to deter crime, not punish it. Punishment is only for those who are incarcerated, right?
So
that's when you're found guilty beyond reasonable doubt, blah, 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 blah.
That
right?
goes right back to the Declaration of Independence for suspending our own legislatures and declaring themselves invested with the power to legislate for us in all cases whatsoever.
Correct.
That's a declared act of tyranny, of tyrants.
Right.
And that's exactly what
so you can right. So you can combine
the legislative branch. We the people are. We're the ones that make law.
There it is. There it is. And you can throw that constitutional doubt canon right next to its constitutional fact doctrine, which from 1937, which states the rule that the federal courts are not bound by an administrative agency's findings of fact when its facts involve whether the agency has exceeded constitutional limitations on its power, especially regarding personal rights. When it comes to everyone in the family law movement, that's the one you got to throw back in their face when they start throwing around the best interest doctrine like Skittles. You throw the constitutional fact doctrine back in their face. Say, okay, you got plenty of claim. I want to see your facts. I want to see your evidence. Because you can't invoke the best interest doctrine if I can counter it with the constitutional fact doctrine. And remember, we talk about the number line. You got a positive and a negative, and you can get to zero. You get them to zero, and that's it. You're done. And that's one of my personal favorites. I use the constitutional fact doctrine, fruit of the poisonous tree doctrine, which is the exclusionary rule. And, I have a couple of my favorites in my arsenal that I love to hit them with, just because it's all basically the same stuff. They've got all kinds of claim, but they got no evidence. They've got no proof of the crime. They got no dead body. So
the corpus delicti,
right? More like corpus defecti. Sorry.
in a de facto governmenti. We are going to wrap this up tonight at the 2-hour mark. I've actually had a few late nights this week talking with a couple of different people here and there about stuff and things.
That makes two of us.
I definitely can even see in my own video here my colored bags under my eyes from lack of sleep. For some reason,
how did you get sleep?
4 or 5 o'clock in the morning and getting up at 9 o'clock with 4 or 5 hours of sleep there just.
I know.
For some reason, I'm not 20 anymore. I can't do this night after night with 4 hours of sleep like I did in the Marine Corps. Man, that was nothing.
Yeah.
Schedule for me 02:30 in the morning. Go to the rack and get up at 05:30, and I, do that for 6 months straight. Now it's fine. Party all night long.
Yeah.
Go to school during the day and party at night.
Oh, those were the days.
Well, I wouldn't even last one night drinking like I used to drink. I'll tell you that right now.
Oh God, dude, you'd be carrying me out of there. Literally, you need a crane to pick my big butt up.
When I say I was a drinker and I was an alcoholic, I drank lots and lots. And I'm not talking a couple of beers, and I'm not even talking like a case of beer. We're talking like a couple cases, like 24 case, couple of those a night. In just a few hours.
I was never a beer drinker. I always liked the hard stuff, but
I wasn't allowed the hard
puberty
stuff.
set in when I hit about 30, so I figured that's enough of that. So.
I wasn't old enough yet. In the Marine Corps, if you're in the military service, you're allowed to drink beer until you're, I think 20. You can drink hard liquor. Maybe it's 21.
Right.
But I mean, when I came home, I went right into bars. I went right into the store and bought beer, Quickie Marts. It didn't matter. I never even got ID'd. Sometimes I got ID'd at the bars. I just flipped my military ID and they'd look at that and have a nice day. Come on in. They didn't actually look at my birth date. They didn't look at anything. They just looked at my military ID and let me in.
Right.
I guess the way they look at it, and that's the way it is on in the military, is if you're old enough to go join the military and die for your country, you're old enough to drink.
Right.
Crap. We here in Idaho, it used to be 19 years of age to buy and drink alcohol. Right before I turned, I think I was only like 16 at the time. They changed it from 19 to 21. I'm like, come on, really? Screw it, I'm going to go join the military.
Right. Like, man, I can never catch a break.
Military, so. Oh, we lost him. Whoops.
Yeah, that's the second time it happened. Chris, nobody hung up on you. Just so you know.
Yeah, I'm the host over here, and I didn't even touch the other mouse over there.
Right. So, call back in. I'll try and message him, make sure.
Yeah, we have 13 minutes here.
Yeah. So yeah, child support. Yeah. What a freaking.
Yeah, Glenita, she just said yes. Buying alcohol was 19 and driving was 14. Yep. In Idaho.
Interesting.
I actually learned how to drive a tractor at about 9 years old. Collection the whole 9 yards. That's all right, Chris. It happens. It happens to me. It happens to you. That's half the reason. That's half the reason why I stopped using Blog Talk, because it would. I'll let it back in. Half the reason why I stopped using Blog Talk initially, because it would just hang up.
Yeah.
That was me. I bumped the stupid off button on my phone. I went to move it, and my hand bumped the stupid button. That was my bad.
Yeah. So we have about 10 minutes left. I don't know if anybody would like to come on and ask a question. No, that's it. Not story time.
Well,
if you've got a legitimate question, call in the number there.
Remember the child support question I asked you a couple weeks ago, and since you're on the topic now, one of the incentives that the courts give the custodial parents to make the non-custodial parent pay is you can get more assistance through the state, like more welfare. Now, if she was to forgive that debt, she'd have to pay back all that. I don't know which one is more. Right. You know what I mean? But there's really no way around it at that point. I'm paying something.
Well, that's where the Bradley Amendment comes in, right? So when we talk about this mechanism that they've constructed to literally sell time,
yep.
Right? A page out of the playbook from our friends and loved ones, the cell service carriers had the bright idea, hey, let's sell time. we can definitely do that. And they went, and we just, you know, that was like, oh God, that's when it gets ugly for us, because they write this credit card amendment, literally the Bradley amendment, and you know, Kerry Speedman and Jay Moss, you know, those two guys, they're real experts on that amendment. They've studied it both in great deal. Kerry, I think, more than Jay, but they can give you Kerry can definitely give you the whole rundown on the Bradley man. We gotta have him on the show.
Who?
I'm gonna reach out to him and see if I can get him to come on.
Who?
Kerry Speedman. This guy can tell you the Bradley amendment, upwards, downwards, left, right, backwards, forwards, squared. You know, he knows it. Good. And I'd like to hear his. I think the listeners could really benefit from his explanation of that, because he can put it in language everybody can understand.
Well, let's get him on here. Have him get in touch with me.
We'll do. I'll reach out to him this week, because
I was going to say we could do a group call.
Yeah, he's a fellow motorhead, so he and I get along just fine.
Yeah,
you're a motorhead too, aren't you?
Folks out there, okay. I grew up around race cars. I was 4 years old.
There it is.
68 to 69 GTO circle track.
Oh
so
yeah.
This is how I got into cars. I started learning what wrenches were and reading the little numbers on there, and you know, I literally helped my dad work on cars.
Mm-hmm.
My mom. You know, my mom knows stuff about cars, okay? She knows how to change oil. She knows how to do stuff on cars. She knows how to change her own freaking tire.
Right.
She knows all that stuff, because back in the day, you know, here in rural Idaho, we're not really much rural anymore, but there's definitely rural areas still here in Idaho, big time. You know, these are things that we were taught as kids. How to change a flat, how to change your own oil, how to change your own spark plugs, wires, cap, rotor. You know, now we have distributorless ignition systems, and all you got is a freaking coil on plug. You pull the coil off, change your spark plug, and put the coil back on and plug it in. You're done. So I mean, the tune-up on
takes all the fun out of it.
Was pretty easy, except for the ones that aren't.
Yeah. Yep. It takes all the fun out of it. We don't have to pull the cap off and set the dwell and the timing and all that every time.
Yep. Set your points. Unless you're lucky and had electronic ignition there, electronic distributor.
Yeah.
Ignition module sitting in there.
Yeah. The only downside
that was the big upgrade,
was
in the
elevation.
That going from points to the electronic ignition.
Yep.
Another thing
between the
going to start doing was actually doing like an automotive tip at the end of my shows here. So one thing you got to know about your car here is you need to check the air in your tires. You got to do that.
Change the summer air to winter air.
Well, no, that's rotating the tires. You have to let all the air out of the tire and put new air. That's rotating the air in your tires.
That's right. Check the blinker fluid, you know.
Check the tire pressure in your tire. One, it's going to save wear and tear on your tires. Number two, it's going to give you better gas mileage. Okay. Other things to do is Seafoam. That's a fuel injection system cleaner. I highly recommend you throw that in your tank like about every 3,000 miles. So just before you go to change your oil, throw that in your gas tank, the whole can, fill it up.
And fill it up.
Ride that around, and it cleans your whole fuel system. Your fuel pump, your fuel rail, your fuel injectors, your valves, your pistons, okay? The top of the pistons get carbon built up on it. And another thing is, stop buying the cheap gas. 87 octane is designed.
I knew we loved it.
It's designed for low compression engines, like long, that kind of stuff. So 89 octane or higher, which I've actually done a test in my own rigs, okay? And I ran my own mechanic shop for 6 years, so I've had several different people do this same exact test. And they run 87 octane in their rig all the time. They know what kind of gas mileage it gets. Throw a can of Seafoam in there, run that through there, and then put 89 octane in. Now, some of the more higher performance engines, like BMWs and, you know, something that's got a V8 in it that's got a little pep to it, they're not going to run on this cheap gas. Oh, they will, but you're going to hear a lot of what's called pinging, ting, 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 ting.
Yeah.
When you give it gas, you're going up a hill and it goes tick, 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 makes that ping noise, little rattle, rattle, rattle. Okay, that's actually pre-detonation, because the lower the octane, the faster the fuel burns. So when that spark plug hits, and it always goes before top dead center, when I mean before top dead center, is before the piston actually reaches the top of the cylinder, the spark plug fires because it's moving so fast. It actually has to ignite that fuel before it reaches top dead center. And so if you're using cheap gas, it's igniting that fuel and it's going bang before it's all the way up and before it goes down. So you're actually causing damage to your engine. So there's some automotive tips for you, other than just law, just trying to kind of put other stuff out there besides law.
That's law of physics. That's pretty good too.
that's the law of maintenance on your rig. Okay.
That's right. That's right. Love it.
Change your oil. You know, you can use synthetic stuff, whatever, you know. That'll go about 7,000 miles. Normal conventional oil is every 3,000 miles or 3 months, whichever comes first. And the reason why is because oil is petroleum based and it actually starts breaking down just sitting on the shelf.
Yep.
Because it's petroleum based. That's just what it does. It breaks down.
Especially after it's been through its process.
And the second you put it in your engine and it heats up and cools down and heats up and cools down, it breaks down the viscosity in the engine, in that oil. The viscosity, that's the part that lubricates and actually puts that cushion between your rod bearings and crank bearings in the block and on the rods.
Mm-hmm.
Actually, that runs a cushion of oil in there. So when the viscosity of the oil breaks down, it no longer functions like it should, and you're actually killing the life of your engine.
Correct.
By not changing your oil. So, you know, I know it costs money to change your oil, but how much does it cost to replace your engine or to buy a new car?
Well, yeah, cheaper to change oil than to change motor. That's what I always tell everybody. Right. It's cheaper
to change your oil than it is to change the engine.
Here's the other thing that a lot of people don't know. Cheapy oil filters. Avoid cheapy oil filters. Spend a little more money and put a little bit better Micron oil filter on it.
Yep.
Not only will it make the engine last longer, but you'll get the filter will trap more of the sludge and the crap than the cheapy one. So again, that'll prolong your engine's life. So,
and make sure you get the
tip from the parts guy
for your car. You know, if your automobile calls for 5W30, and I'll explain what that means. 5 winter is what it's known as. So cold, when the engine is cold and the oil is cold, it's 5 weight. It's super thin, so it moves real quick. And then the 30, the second number, is actually the weight of the oil once it's fully warmed up. So oil actually, I mean, think about this. Your engine's completely cold, which is the worst on your engine is the cold start, the initial startup, because there's no oil pressure on your rods and mains. So this is why if you read your manual, it'll tell you to start your engine and let it run for 1 minute before you do anything, at least 1 minute. That's so it can build up oil pressure. But that oil viscosity changes as the engine warms up. So you have to be careful and not to mix oil either. So like if you put 1030 in the winter and 1040 in the summer, and you got 1040 in there and you're, oh, well, I can't remember which one, and you dump 1030 in there, I'm not going to say it's horrible bad, but you just mix the viscosity from, 1030 and 1040, so the oil doesn't know which viscosity to be at, So anyway.
Absolutely. And I think Ted's just given us our our final credits here. So we go ahead and pay due respects to the to the powers that be and our sponsors and everybody else.
Yep. Thank you for joining us, folks. Thanks for sharing. Like and follow Kirk's Law Corner, the page there. I also have a private group. If you'd like to get into that group, send me a message. That's where all my PDF files and all these files are. Some of these files that I talk about, they're in there, in the private group. They're not on the page. So if you want in that group, either send me a private message saying you want me to add you, because I'm not going to add you. I'm not going to add you like other people add me to groups. Man, that's been crazy, trying to remove myself from all these groups that people add me to. Yeah. Like, follow, share, please, if you enjoy the show. If you don't enjoy the show, well, obviously don't like and share and follow. But if you do, I'd appreciate it. All about education, folks. Doing what we can to help educate the people.
Considered for educational purposes only.